बोल देता हूँ बंद। हेलो।
हाँ नमस्कार भाई साहब।
नमस्कार नमस्कार, कैसे हैं?
बस ठीक है,
बढ़िया।
बिल्कुल ठीक है सर।
आवाज आ रही है?
एक सेकंड रहा।
मतलब वो कर दे।
ये शेयर स्क्रीन का ऑप्शन है।
हाँ, यहाँ से अपने को लेके मेरे को डाल दो इसको। तो गुड इवनिंग। How is it possible? How is it possible? Oh, okay, okay. I am just forwarding you. Okay, okay, no issue, no issue. Okay.
क्या कह रहे हैं आप?
आईडी पासवर्ड तो दे दी, कहाँ से रुपये जो है वो रहे हैं।
आईडी पासवर्ड आपने मुक्त रखा है?
वो कर दे, ये बंद कर दो, म्यूट कर दो।
दे माउस लेकिन आवाज आवाज आवाज।
Good evening, Parveen sir. We should wait for other participants. We should wait or we should start, sir?
Good evening, good evening.
Yeah.
We should wait just 2 or 3 minutes.
Okay, sir. Fine. Thank you, sir.
You are also co-host.
Okay, sir. Fine. Thank you, sir.
अच्छा अच्छा।
ऑस्ट्रेलिया ठीक है right. ये जो इनको भी ऐड करके और फोल्ड कर दिया इसमें CSV और हेलो यस 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 no registration required joining link I think there no you can write down ID and password if you are aware. No issue, no issue. You note down ID password so that you can join. 019 641.
Power on. Get ready to go to the future. Bluetooth mode. Your device is ready to pair. You are now connected
Hello,
to
change
your
हो गया
Amazon One.
passport. How लेगा passport और पास पहले वाला है ना नहीं अब चेंज हो गया क्या Hello. Hello.
Yes, sir. Hello.
Now we can start.
Yes, yes, we can.
Please,
Surely.
please start.
Okay, sir. Fine. Thank you, sir. So I, Dr. Trupti Rathi, on behalf of GIPA Professional Associations and APAR Professional Services Private Limited, welcome you all. Good evening, all. And especially today, we are having with us the eminent speakers, that is CA Parveen Jain sir and IP Rajiv Khurana sir. So we would like to welcome them. So before going ahead, I would like to introduce about the GIPA Professional Association and APAR Professional Services Limited, Private Limited. After that, I will introduce CA Parveen Jain sir, and then also I would like to introduce IP Rajiv Khurana sir for today's session, that is discussion on pre-insolvency and pre-package insolvency. So thank you once again. So first, I would like to introduce about GIPA Professional Association. So this particular company incorporated in India and registered with Ministry of Corporate Affairs in the year of 2020 with Register of Companies of Delhi and licensed with Government of India with the main object to provide all kind of awareness and facilitation services for business professionals and students in India and abroad. The directors of GIPA Professional Associations are CA Parveen Kumar Jain, Advocate Piyush Jain. The vision of this GIPA Professional Association is that the company will to become a leader by giving awareness and facilitation services across the globe, especially for social and public welfare. The mission is that providing awareness and facilitation services, including advisory services by way of webinar, seminar, certificate courses. And I would like to mention here that almost on every Saturday, we conduct these sessions and we have the best think tankers, best speakers also for this particular forum. Further, I would like to introduce APAR Professional Services Limited. This company is also incorporated in India and registered with Ministry of Corporate Affairs, MCA, in the year of 2013 with the ROC, Register of Companies of Delhi and Haryana, New Delhi. With the main objective is that to provide all kind of professional consultancy services, including insolvency professional support services, apart from other advisory and consultancy services in India and abroad. Here the directors are Miss Vandana Jain, Shri Pramod Jain and Piyush Jain. The vision is that to become a market leader by giving quality professional consultancy services across the globe. The mission is that providing consultancy services, including expert insolvency support services, and functioning as event manager of GIPA Professional Association, NGO, not for profit organization, registered with MCA and licensed by Government of India. The advisory board is CAIP and RV Parveen Kumar Jain sir, CA, CS and CMA Mahindra Rastogi, CA and IP Rastogi sir, IP RK Goyal, IP AK Srivastav, CA and IP Rajkumar Adukia, Advocate CA Nipun Singhvi, CA Dinesh Jain sir, CA Pushpendra Dikshit, CA Ashish Jain sir, and CA Megha Jain ma. So here, this is the brief introduction of these institutions, professional institutions or bodies, I can say. Now further, as I have said that we have the eminent speakers with us, that is CA Parveen Jain sir and IP Rajiv Khurana sir. So first I will introduce CA Parveen Jain sir. I hope I am audible to all of you.
Yes, please.
Yes, yes.
Okay, thank you.
Please.
So CA Parveen Kumar Jain sir is having the experience, this professional experience more than 40 years. He's a chartered accountant registered with ICAI holding COP. He's also the insolvency professional registered with IBBI holding AFE. He's also the registered valuer registered with IBBI holding COP. He's also the qualified independent director registered with IICA of MCA. He has also done various diploma and certificate courses, such as he has done the certificate course for forensic accounting and fraud detection. He has also done the certificate course on arbitration and conciliation. Further, I would like to mention that Sir is also the director in Messrs MCKM Insolvency and Resolution Services Private Limited, MCKM Private Limited. He's also the managing partner of Messrs Parvin K. Jain and Associates, Chartered Accountant since 1990. He's also the chairman of Messrs Apar Professional Services Private Limited. Formerly, it was named as Vijay Professional Consultancy Services Private Limited, which was registered in 2013. He is also the founder director of Messrs Apar Insolvency Professionals Private Limited. He is also the proprietor of Messrs Apar Valuation. It's a really we should give a round applause for Sir, because definitely it's a very strong profile. He's also the ex-founder director, Messrs Apar Valuation Professionals Private Limited. He's also the chairman, GIPA Professional Association, which was registered under Companies Act, Section 8 of the Companies Act 2013. He's also the chairman of Association of Dispute Resolution Practitioners. So here we welcome you, sir, for today's session, that is pre-insolvency and pre-package insolvency. Further, I would like to introduce IP Rajiv Khurana, sir, ex-DGM, Central Bank of India, Director, Apar Insolvency. Sir has done his MBA, BSc. As I have said, he was also the ex-DGM, Central Bank of India, Senior Banker, IP North. Mr. Khurana is an ex-banker, having worked with Central Bank of India for about 40 years and retired as Deputy General Manager in SAM and Recovery Department Central Office. At present, Mr. Khurana, as an insolvency professional based out of Delhi, is associated with us as the director of Apar Insolvency Professionals Private Limited and handling stressed assets management, IBC related matters, and also take care of IBC assignments and business development for advisory services. Yeah, I think so. Yes. Here I would like to welcome IP Rajiv Khurana, sir, for today's session, that is pre-insolvency and pre-package insolvency. Thank you all, and I request to CA Parvin Jain, sir, to start with his session. Thank you.
Thanks to Dr. Tripti Rathi. She is also a very prominent educationist and prominent in law, and very active in webinar, seminar, and insolvency proceedings. And also very thankful to Mr. Rajiv Khurana, our partner in Apar Insolvency Professional Private Limited, and all the participants. I once again welcome to all. With this, I start with the topic of pre-insolvency. We are doing with this our triple P insolvency model, means pre, present, and post insolvency. And first of all, we are focusing on pre-insolvency. So we are now sharing my screen for presentation of my slide. So pre-insolvency means pre-insolvency is the process of avoiding failure or stabilizing a struggling business and making changes that lead to sustained improvements and regrowth. Means pre-insolvency is the stage where the business or industry is facing financial crisis, debt ridden, and in debt trap position, and not being able to continue without any support of experienced insolvency advisor or so experienced professionals. So there are some causes of the failure of the business. That is why the insolvency advisors role come forward. The main solution of pre-insolvency to overcome the financial stress is turnarounds. That is most effectively industry developed in these decades. Turnarounds means are fundamentally different to fast growth or steady state business, which is why a turnaround industry developed. Turnaround can be defined as a period of poor performance that moves into a period of financial recovery. This can refer to an individual or nation's economy as well. Turnarounds are important and crucial time as they mark a period of improvement that brings stability to an organization's future. To create a turnaround, an organization must identify problems, be ready to consider changes, and develop and put a problem-solving strategy into place. Next. The main the warning signs that show companies are under pre-insolvency stage are that attracts role of insolvency professionals and experienced professionals to overcome who will help industries to overcome the pre-insolvency stage, which are close to down the business. Number one is cash flow issues, late payments, creditor pressure, legal issues, dealing sales and revenue loss and key customers and contracts, bank restrictions, staff morale and productivity, personal stress, maximum borrowing, no money to pay staff wages, balance sheet test, demand for payment, no reliable management information. So I would like to state one by one. Cash flow issue: if your business consistently struggle to meet its financial obligations and to balance cash flow in and out of the company, you might be facing liquidity problems. The experts at company insolvency advice can talk you through several short and long-term situations to cash flow challenges, which could return your organization to good financial standing if they are implemented early enough. Late payments, frequent delay in settling bills and paying staff salaries may be an early sign that your business is not functionally stable. Credit pressure: if your company's creditors are constantly chasing payments and you are receiving final notices, that is a red flag. Even if you are able to pay these debts or you work in a volatile industry, making late payments suggests that there may be structural problems within your business. Contacting our legal issue: if you are facing legal action from creditors ranging from winding up petitions to current court judgments and CIRP initiations, it is vital to seek professional advice at the earliest opportunity. Even in these cases, it may not be too late to save your business, provided you act quickly and make the right moves. Declining sales and revenue, loss of key customers and contracts. A sudden drop in sales and revenue could mean you will soon face difficulty in maintaining the business. This can also incur if you lose a major client or a significant contract, as this may seriously affect your revenue stream. Sometimes these situations cannot be avoided. For example, if a customer goes out of business, it is not easy to quickly replace them and revenue you have lost. However, with sincere advice from a licensed insolvency professional, you may be able to take steps to reinforce your company's resilience in these types of challenges. Bank restrictions: if your bank has declined further credit or is tightening your existing credit liabilities, this is a red flag. And you should work with an insolvency professional to determine an appropriate way forward for your company. Along with these financial indicators, there are also personal effects and responses to these challenges that can make them more difficult for companies to deal. This is another reason that working with a professional can also be fruitful to rescue the business. Staff morale and productivity: low morale and declining productivity often accompany financial difficulty and can accelerate them. Shareholder or directors dispute disagreements at a high level about the future direction of the company can result from deeper financial issues and make them more difficult to resolve. Personal stress. Running a business is challenging if the financial state of the business starts affecting your personal well-being. Considering that as a signal too. And other one in maximum borrowing. You have unpaid company debt and the business has reached the limit of your bank overdraft and has been refused further credit. No reliable management information. There is nothing in the company that can provide crucial information about its performance. Balance sheet test. This tests the likelihood that the value of your business asset is less than your liability. To determine this with any accuracy, you will need to appoint an independent valuer to assess the business assets correctly and consider all contingent liabilities. Struggling with pre-insolvency or the business has to consider and appoint an insolvency practitioner or insolvency professionals so that he can rescue their business. Next. Solutions to overcome from pre-insolvency stage through turnaround stages are company voluntary arrangement, prepack administration, time to pay arrangement, creditor voluntary liquidation, value creation through turnaround strategies, acquisition, merger and takeover, management buyouts, restructuring. And management change, personnel cuts, reorganizing, going private transactions, company going public, high dividend policy, that are very useful tools to rescue the business going into liquidation. How turnaround and restructuring consultant help crisis management, bankruptcy reporting and administration, strategy, alternative and business planning, operational improvements, debt capital advisory, stakeholder communication, M&A advisory, etc. With reference to our turnaround. It is in a turnaround. In a turnaround, director duties can quickly change from rewarding the shareholders to protecting the creditors. The fair treatment of creditors need to be well understood. The Companies Act 2006 need to be interpreted along with the Insolvency Act. The concept of going concern and look forward test often taken for granted become critical issues and need to be fully appreciated. Valuation assumption change, preference law emerges as a guiding principle over the fair distribution of shares. The turnaround committee has to work at pace and with certainly because there is generally only one chance of success. If that assessing business leaders and their staff who will often by way of outside the port zone and faced with worry. If this chance is forgotten, the company definitely will go in liquidation. I once again define turnaround. Turnaround can be defined as a period of poor performance that moves into a period of financial recovery. This can refer to an individual or a nation economy as well. Turnarounds are an important and crucial time as they make a period of improvement that brings stability to an organization's future. To create a turnaround, an organization must identify problems, be ready to consider changes, and develop and put a problem-solving strategy into place. Just a minute. How a business turnaround works. After problems within a company are identified and effective decisions have been made to provide a framework for business decision making to solidify goal prioritization and resource allocation in business environments. A turnaround financial consultant will assess the degree of distress. This is done through review of the entire company. The area that needs the most attention will be assessed first and a strategy will be agreed on. Depending on the size of the businesses, the complexity of the problems, and how much help the business wants from the consultant, and engagement must last 2 to 3 years. There are specific characteristics that will identify an organization in need of a turnaround. This might include declines in the price of its stock, the need to pay off employees, and revenue that do not cover requirements to pay creditors. Changes in a firm's competitive advantage and outdated products or services may also be indicative of a business that needs to investigate both turnaround and restructure strategies. Example of a turnaround: in 2009, General Motors declared bankruptcy as a result of the crisis, and its stocks were delisted from trading. Bailout funds and its bankruptcy helped the company restore its manufacturing, production, and sales. In 2010, after a complete reorganization, GM's stock began trading again with increased production and sales. That is more important for to rescue the business from pre-insolvency stage. Thanks a lot, and I refer to Dr. Tripathi to go forward. Thanks.
Thank
you,
you, sir, for giving insights on warning signs that shows companies are under pre-insolvency stage, and also you have guided us on how turnaround and restructuring. So thank you, sir. And now I further request to IP Rajiv Khurana sir to deliver a session on pre-package insolvency. Thank you, sir. Thank you.
Thank you, Dr. Rathi. Thank you, Jain Sahab. Thank you, participants, for giving me an opportunity to have an introduction about the PPIRP process. So first of all, before proceeding toward the PPIRP process, I would like to differentiate between the CIRP process and the PPIRP process. So there are 10 differences are there, basically, which we have to keep in our mind in relation to the PPIRP process. Number one, it is covered, the CIRP process is covered under Part 2 and Chapter 2 of IBC. PPIRP process is covered under Chapter 2, Part 3A, which was subsequently introduced by the central government. Then, about its applicability, any corporate debtor can initiate the CIRP process as per his eligibility criteria. But as far as the PPIRP process is concerned, for this, it should be the MSME sector. This is the basic difference. So MSME, if the corporate debtor is from an MSME sector, only then he is eligible to go forward in the PPIRP process. Second, its priority. As far as Section 11 is concerned, in case two applications are there which have been filed with the adjudicating authority, one application has been filed under the CIRP process and another application has been filed under PPIRP process. So then, first of all, the first priority will be given to the PPIRP application. Only the CIRP application will be heard only in case the 14 days are over. For example, if today is, for example, 3rd of August 2024, if two applications have been filed on 3rd of August 2024, one application under the CIRP process and one application has been filed under the PPIRP process, so then the adjudicating authority will give its verdict or his decision on the PPIRP application first, as far as the Section 11 is concerned. Second, in case an application has been filed on 1st of August and another application has been filed on 13th of August under the PPIRP process. So because the 14 days are not over, still the PPIRP application will be heard first. Only the deviation is there when the PPIRP application is filed subsequent to 14 days. That is, for example, if on 1st of August, the CIRP application has been filed, and another application has been filed on 15th of August or on 16th of August under the PPIRP application, so then the CIRP application will be disposed of first by the adjudicating authority. This is the first of all, it is the priority, as far as the priority is concerned in relation to Section 11. Then, minimum amount of default. This is the major, another difference is there. So minimum amount of default under the CIRP process is 1 CR, and whereas in the PPIRP process, the minimum amount of default is rupees 10 lakhs. Then, another differences are in relation to the preliminary work. Under CIRP process, there is no preliminary work is there before the filing of application to NCLT. either by the financial creditor or by the operational creditor. Only the CD has to give the specific resolution plan in case he is going for a filing of an application under section 10 of CIR process. Whereas in case of PPIRP process, very exhaustive preliminary work has to be done by the CD as well as by the RP. Now, another difference is really in relation to who can initiate. As far as the CIRP process is concerned, financial creditors, operational creditors, and the CD himself, they can initiate the process of CIRP process under section 7, section 9, and section 10. Whereas in case of PPIRP process, only the CD has to initiate the process. Then next difference is in relation to the timeline. Here, there are maximum under the CIRP process, maximum 330 days are available for the completion of the whole process. Whereas in the PPIRP process, only 120 days are at our disposal. And out of 120 days, the RP is having only 90 days at his disposal, and rest 30 days are with the adjudicating authority, either to accept the proposal or they have to reject the proposal. Then, appointment of IRP. Under CIRP process, there is a concept of interim resolution professional, whereas under the PPIRP process, there is no appointment of IRP. Then, management of CD. The corporate debtor is managed by the IRP from the date of admission of the application. Whereas in case of PPIRP process, the management of the company runs with the, it is vested with the CD, unless and until there is any particular pecuniary fraud, etc. is there, and for which the COC gives the authorization to the RP to file an application along with Form 14 with the request to the adjudicating authority, that is, the company is not running well, so now the power of the company should be vested with the RP. Now, constitution of COC. Under the CIRP process, the COC has to be constituted within 30 days of the insolvency commencement date. Whereas under the PPIRP process, because of its importance, the constitution of COC has to be made within 7 days of PIRP commencement date. Then, information memorandum has to be prepared by the resolution professional in case of the CIRP process. Whereas in case of PPIRP process, the information memorandum, or which is also called the preliminary information memorandum, it is prepared by the corporate debtor himself, and then it is discussed with the RP. And wherever the certain modifications are required, then they have to be done. Then, base resolution plan. Here, there is no such concept about the base resolution plan as far as the CIRP process is concerned. And the main pillar for the PPIRP process is the base resolution plan, which is given by the corporate debtor who is intending to go for the PPIRP process. Then, there is no specific provision for the Swiss challenge method as far as the CIRP process is concerned. As far as the CIRP process is concerned, there is no specific provision as far as the Swiss challenge method is there. But under the PPIRP process, the Swiss challenge method has to be taken into account before giving a, you can say, approval by the COC for any resolution plan which is submitted by the prospective resolution applicants. Then, approval of resolution plan. In both the cases, the approval of resolution plan is made by the adjudicating authority. So these are the basic differences between the CIRP process as well as the PPIRP process, which we have to think and which we have to keep in our mind before we are taking any assignment in relation to the PPIRP process. And the second beauty of this PPIRP process is this, that is, under 5 scenarios, you will be required to take the voting percentage into consideration before passing. And for all these things, you have to take the voting percentage of more than 66%. So in the PPIRP process, everywhere, wherever the voting will be required, so you have to take the voting by value of more than 66%. For example, there are 5 scenarios are there. One is 54A, where there are various approvals are there. Various approvals are sought, right, in order to act as an RP for PPI-RP process, and then the approval of to file an application with the adjudicating authority for PPI-RP process. For these approvals also, the voting percentage of 66% will be required under section 54A. A means approval. Then comes 54J. J means when in case it is thought that is the management of the corporate debtor has to be vested with the RP because of certain, you can say, misconducts by the CD. So then also, then the approval of the resolution approval by the COC will be sought, for which the 66% age of voting will be required. Then, in case the COC is giving an approval for a resolution plan, either the base resolution plan or another subsequent resolution plan, which are received from the prospective resolution applicants, in that case also, the 66% voting percentage will be required. Then, in case the COC decides that is the PPI-RP process has to be terminated, in that case also, the voting percentage of 66% will be required under section 54N. N means nahi hua. Then 54O, in case otherwise, since the PPI-RP process is not found applicable and it has been terminated as far as the COC has given their approval with 66% voting share, and in case the CD is eligible to go for the CIRP process, also again in that scenario also the more than 66% voting share will be required under section 54O. So only under the 5 scenarios, 54A where the approvals are sought, then 54J means ji haan, 54K, K means kanun, then 54N, N means nahi hua, 54O, O means otherwise. So these are the 5 scenarios which will be applicable for the PPI-RP process and for which the voting percentage of 66% will be required. Now, looking to the paucity of time, I am not going for the sections in this today's session. I am taking a case study so that you can be benefited by that case study. There is a case, it is a Nature Limited is there, and he is a micro enterprise as per section 7 of MSME Development Act 2006. He has filed an application for initiation of PPI-RP process under section 54C. So filing of an application for initiating PPI-RP process will be in terms of section 54C. Just you have to remember this section is very important. And you have been appointed as a resolution professional to conduct this PPI-RP process. Now, in the just you have to understand that is Nature Limited is a micro enterprise. He has filed an application for initiation of PPI-RP process under section 54C, and you have been appointed as a RP to conduct this whole process, for which the initial thing is the Nature Limited has prepared a base resolution plan, right, which he has submitted to you, and after constitution of the COC, then within 7 days, then that base resolution plan is placed by the RP in front of COC, and then the COC evaluates this base resolution plan. The first step, again I repeat, the Nature Limited has prepared a base resolution plan, and which is given to RP, and RP in turn has given, after the constitution of COC, has placed it before the COC for its evaluation. Now, while evaluating the proposal, it is found that is this base resolution plan impairs the claims owed to few operational creditors. What it has been observed, that is there is a haircut against the claims given by the operational creditors. Now, our role is in the capacity of RP, now we have to advise to COC whether it is mandatory for them to approve the base resolution plan, and if not, the process in which they can invite alternate resolution plans. So being an RP, we are having a scenario as explained above. That is, we have to advise the COC whether it is mandatory for them to approve the base resolution plan given by the nature corporate debtor, or what is the procedure by which we can invite the alternative resolution plans. So, as per section 54K, K means Kanun, I have told you. The following is the manner of initiating the PPIRP process. Number one, it is the submission of base resolution plan. As I have told you, the corporate debtor shall submit base resolution plan to the RP within 2 days of PPIRP commencement date. It is a submission. It is the first step. Second step is the presentation of base resolution plan to COC. So the RP will present the base resolution plan to COC within 7 days when it is constituted. The third, first is the, you can say, submission of base resolution plan, preparation of base resolution plan by the CD, and second is the submission of base resolution plan before COC by the RP. Now third scenario point is now the CD will be given an opportunity to revise the base resolution plan. The COC may provide the corporate debtor an opportunity to revise the base resolution plan prior to its approval or invitation of prospective resolution applicants, as the case may be. So there are two scenarios. The COC found that is, this base resolution plan should be improved by the corporate debtor. So then the COC will give an opportunity to the corporate debtor to improve this base resolution plan, for which the main important thing is that is, before, if once they have approved it, the base resolution plan, then they cannot go backward, and then they can not say to the CD to improve it further. Before the approval of resolution plan given by the CD, they have to take they can give an opportunity to CD to improve his base resolution plan as per the merits of the case. Second, once it has been approved by the COC, then the RP will be submitting the approval with the approved minutes of the COC to the adjudicating authority, requesting therein that is, this base resolution plan has been approved by the COC, and the main condition is here that is, it does not impair any claims owed by the CD to the operational creditor. In case the base resolution plan gives an impairment to operational creditors, then it is not allowed. So then that resolution plan will be rejected by the COC because it is an impairment. Impairment to financial creditors can be there, but impairment to operational creditors, looking to the, you can say, the focus on the MSME sector. So under the PPIRP process, the operational creditors are eligible to get their 100% claim amount from the corporate debtor. In case there is an impairment, so then that resolution plan will not be passed by the COC, and then the COC can give an opportunity to the corporate debtor to improve the base resolution plan. Now, what in case if there is an, you can say, haircut to the operation creditor, it is called as, that is, the base resolution plan is biased. What is the word? It is, the word is biased. So the COC will not approve the base resolution plan in case there is a haircut to the operational creditors. Right? Now, an opportunity was given to the CD to improve his offer. And if in case the CD says that is he is not able to improve his offer further, then the COC can discuss with the RP, and then they can invite the resolution plans from the market, that is from the prospective resolution applicants, right? And there is a procedure is there as like the CIRP process. So, for example, there is a, you can say that is the CD is having an outstanding of 50 lakh rupees to the various creditors and including the operation creditors, and he is saying that is he can give the you can say amount to the tune of only 40 lakh rupees. So there is a haircut of 10 lakh rupees. So this haircut of 10 lakh rupees can be given to financial creditors, and for which also there is a meeting will be held. But as far as the operational creditors are there, so there will not be any haircut. Now, looking to the assets and all the other things, and looking to the present company going activity. So if the COC says that yes, we should ask the better resolution plan from the market, then they can invite the other resolution plans from the prospective resolution applicants. So then the prospective resolution applicant will be giving another plans. For example, there are two prospective resolution applicants are there, and one has given a plan for 42 lakhs and another has given a plan of 48 lakhs, for example, in the same case. So then the first of all, again the COC will approach to the corporate debtor stating therein that is we are in receipt of two plans, one plan of 42 lakhs, you have given a plan of 40 lakhs and another plan of 48 lakhs. So whether you can improve his offer up to that level of 48 lakhs, whether you can enhance your bar from 40 lakhs to 48 lakhs. In case he says yes, so then first opportunity will be given to the CD to improve his offer to 48 lakhs. In case he says that he is not capable to improve his offer further, so then the COC may decide that the resolution plan which was given by the looking to the economic and other viability aspect, then they will say that is the prospective resolution applicant who have given the offer of 48 lakhs rupees. So he will, this resolution plan is passed by the COC, and then the RP along with the minutes of the meeting, it will be submitted to the adjudicating authority with a request therein that is this is the proposal which is for the this PPIRP process, and then the adjudicating authority has 30 days in it at its disposal to allow or to reject this proposal. Now, in case, so this is called as the fulfillment of criteria laid down by the RP in consultation with the COC. Now, here, before going for the, you can say, prospective resolution applicants, so he has to provide the two things. First, he has to provide the basis for evaluation of resolution plan as approved by the COC. So the evaluation aspect will also be given by the RP. And second, he will be giving the criteria, that is what are the details which has been provided by the preliminary information memorandum submitted by the CD. It will also be shared with the prospective resolution applicant, stating therein that is he has to keep the secrecy of the case. Now, these are the 7 steps which we have to keep in our mind before going for the PPIRP process. And we have to discuss with the COC and according the best resolution plan, which is not giving any haircut to the operational creditors, will be allowed to be placed before the adjudicating authority after its approval by the COC. Now, in this present case, Nature Limited has prepared a base resolution plan, but here there is a impairment to the claims owed to the CD. So in such a case, in view of the above provision, the RP can invite the resolution plans from the prospective resolution applicants because the impairment to operation creditors is not allowed. So what is the conclusion? So conclusion is that it is not mandatory for the COC to approve the base resolution plan submitted by the CD. So it is not mandatory. In case where the base payment plan impairs the claims owed to operational creditors, the COC may either provide an opportunity to revise the plan or shall invite new resolution plans from the prospective resolution applicants and select the most suitable plan, so that there should not be any impairment to the operation creditors on one side, and second side, that is, there should be the minimum haircut to the financial creditors. So am I clear in this case study?
Yes, sir. Yes.
So now, because looking to the short time at my disposal, so I have thought that is I should discuss the case study so that it will be more fruitful for the participants to understand practically, and about the sections and about the, you can say, the forms, etc. In the next week, we can again discuss about these forms as well as about the various sections from 54A to 54O, out of which 5 sections I have already discussed while evaluating the voting percentage of the creditors. Over to you, madam. Thank you.
Okay. Thank you, sir. Thank you. Thank you, sir, for enlightening us on the detailed pre-packaged insolvency and the case study so that we can understand the practical aspect of this particular concept or a process. So thank you, CA Parveen Jain, sir, and thank you, Rajiv Khurana, sir, for giving us the detailed information, knowledge on insolvency and bankruptcy. Very specifically, the topics are the preventive insolvency and the pre-packaged insolvency. Thank you, audience, participants, members, for joining this particular session. Every Saturday, usually we conduct this session, and the registration is altogether free. So this is a very important feature of this particular session, which are arranged by GIPA Professionals Association. Association with this APAR as well, right? So I hope that anybody is having the question, by the way, so you can ask the question. So you can unmute yourself and you can ask the question. Otherwise, you can put the question in the chat box and we can read out for all of you. Thank you.
Otherwise, anyone can send the questions in our mail ID or contact our mobile number.
Yes.
Thanks, Dr. Trupti Rathi. So nice for conducting a webinar in such a manner to a fruitful discussion. And thanks, Rajiv Khurana ji, our speaker and our partner, and also all the participants for their valuable time contribution. Thanks, Andor. And we will arrange shortly for a further discussion on this topic also. Thanks, Andor.
Thank you, sir. Thank you. Thank you, Dr. Rathi. Thank you.
Thank you, sir. Thank you. Thank you. Good day, all.